Good morning, yes, Mr Westgate. Just before you start, can I ask what the position is, or perhaps this is what you were about to tell us, about the note we asked for yesterday, I think not actually in your case, but from the parties in Elkundi, about the various changes in the Act. I see we've got a couple of bits of statute here, which may be the relevant ones.
Perhaps I should let Mr Nabi.
I think you should, yes. Mr Nabi.
Yes, my lord, yes. So what you have in front of you there, firstly, is the original section 69. That was, forgive me, the original section 69 that came into force with the passing of the Housing Act 1985.
Yeah.
And then the second sheet is section 69 as amended by the Housing and Planning Act 1986.
That's very helpful. I'm sorry to be picky, but I think what we really wanted was a note. It need only be a few sentences, and these can be exhibited to it. But an agreed note just showing what the changes were that we discussed on the last occasion.
My lord, I apologise.
It doesn't matter, but I'm sure it won't be long to do. But no. If you could do that. The reason I raise it now is we have discovered another oddity about the drafting history, which my Lord Justice Lewis is more on top of than I am, and he will just raise with you, because I will get it wrong.
Just to make sure that we've got the right statute that applies in these cases, because the statute we've got, and for example, at 96 of the Authorities Bundle, the Section 193 statute section, that refers, for example, at the end to the authority's duty to the applicant until Section 189B2 has come to an end. Yes. That's the 56-day period after 6 months of provision of help. And I've been puzzling as to how that worked. But it seems the answer is the Homelessness Reduction or Reduction of Homelessness Act 2017 put the Section 189 duty and other bits into the Act.
Yes.
They only apply to applications after a certain date, yes. April 2018, and none of these 5 cases were after that date. They were all before that date. So certain bits of this Section 193 don't actually apply. In this case, 193C can't apply, can it? But was the rest of it the same before? It's knowing which provisions applies.
My lord, that is right. So the Act was amended after the Homelessness Reduction Act. The various versions of Section 193 are set out at tab 8 of the bundle of authorities,
right.
Which is starts at page 131.
So is this? So it is different then. So it's much simpler, and it doesn't have all the 7As and 7ABs and so on. So are you telling us that it's this much simpler provision that we are actually construing, not the complicated one we've been looking at?
Well, Section 1932 is the provision that we are principally concerned with.
Yes, but you've got to see it in context.
Yes.
You've got to know which provisions are on either side of it.
Yes, but 1932 has remained unchanged throughout.
Well, we're aware of that, but I mean, being Lord Justice Brickbat again, it was a very clever idea and a good idea in principle. The authorities bundle thought this was we were given the whole of the Act in tab 7 of the authorities bundle, sorry, the whole of part 7. And then as part 8, something called iterations. And I thought that's very helpful. The bit we're concerned with is in part 7. The iterations is just little bits of history which may be referred to in the course of submissions.
Yes.
But in fact, that's not right. Section 7 of the authorities bundle is the Act as it now stands,
yes.
Not the Act as it applies to these cases. You've made the point about 193. I do understand, but as my lord said,
yes.
The fact that 1932 is in identical terms isn't the end of the story. We've got to understand it in the context of the surrounding provisions. And the surrounding provisions, we want to be the surrounding provisions as they were at the date to which these claims relate. So I'm not asking, these things happen, I'm not asking for any apology or anything, but can we, is this right? We shouldn't actually be looking at part 7 or tab 7 in the Combined Authorities bundle as containing the legislation with which we are concerned.
It becomes critical when you look at 131 because there are very different provisions about the period of time and the termination. 1933, for example, says that the authority is subject to the duty for a period of 2 years.
So the 2-year provision went very early. That went by the introduction of the Homelessness Act 2002. Well, perhaps it might be of assistance if, again, I prepared a short note just setting out how 193 evolved.
No, what I need to know is which statutory provisions apply. I thought from the 2 days you've had that it was 193 at page 96, and it's quite complicated. It's easy to work out when it starts, it's quite complicated to work out when it finishes. You then told me this morning it's page 131, so I looked at that, and immediately, and you told me that applied. I could see that there are provisions there that the duty applies for 2 years, but you now tell me no, that had gone by the time of this case. So which page am I meant to look at to know which duty applied to your client's case? You probably can't do it immediately.
Look, it shouldn't be too difficult. I'm teaching, I'm sure, my grandmother to suck eggs. If you go to Westlaw, you can get the Act as it stood at a particular date. There are slightly different dates for the 4 appellants, but with a bit of luck, it is the same version for all 4, but maybe not. And I think probably also in the Imam. I haven't even begun to, we only spotted this problem this morning, so I may have got it completely wrong. What we need, and as soon as possible, because we want to start writing a judgment, is an equivalent of, well, we want a copy of the whole of Part 7 as it stood at the relevant date. And if it's different relevant dates for different cases, well, we'll have to have one for each of them. Yeah. And that's in addition to the note that you kindly offered. I'm sorry, because you're on your feet, you're getting the brunt of our slight irritation. I have no idea who took responsibility for putting this bundle together, but ultimately it's a joint responsibility. But I'm sure it's we shouldn't be shouting at you.
No.
But that's how it worked, that's how it pans out. But could that be done as soon as possible?
That will be done today, Mike.
And if we've got the wrong end of the stick, do say, but I don't think we have.
Well, I would like to be absolutely certain before I...
Yes, you feel free to produce a note saying, or to stand up again at lunchtime and say, you have got the wrong end of the stick, the bundle is exactly what it should be, and then we'll eat humble pie. But at the moment, it doesn't look like that.
I'm grateful.
Is that?
Yeah, that's the answer, yes.
Good. Thank you.
Yes, my lord, can I, before I get on to what I was going to deal with...
Yes, quite.
Can I deal with how this point applies to Imam, as I understand?
Yes, quite.
Paragraph 30 of the judgment, the point was noted, in page 43 of the call line, that amendments had been made to Part 7 of the 1996 Act by the 2017 Homelessness Reduction Act.
Yeah.
I think that's what put my lord onto it, actually.
Yeah.
Exactly, but they don't apply in the case of the claimant. And so the judge then refers to the unamended provisions of the 1996 Act. When he says unamended, I think what he must mean is unamended, as not yet amended by the 2017 Act.
Yeah, but it's
there
still
had, of course, been amendments before.
gives rise to the problem as to whether it's page 96 or 131. It may not be 131 either. But in fact, the judge sets them out in his case.
Yeah. The correct one, although we probably don't need to go to the detail of it, is, I think, at page 150, which you'll find is the version in force as at the 9th of November 2012, and then the next one in the bundle is as at 24th April 2015, by which time the Imam application had been
Yes. I mean, the other thing, sorry, going back to it, I'd say the idea of Section 8 of the Authorities Bundle with the previous versions was a good idea, but you're not given any guide to watch which applies when. There's just a whole series of sections without any...
No, my lord,
so it's pretty difficult to use. Anyway, lessons for next time.
It's, so far as Imam is concerned, and I say this not in any way attempting to excuse the point, it really doesn't turn on the various iterations of it.
No. I mean, I don't think, to us it doesn't turn on them either. It's just we've got to understand what we're dealing with.
No, indeed.
And also make it clear, because it may or may not be relevant for people who read our judgments later, what state of the act we're dealing with, because for all I know, these issues, or 1932 we're told is the same throughout, but some of the things we may say around the edges may have may be obsolete.
Well, certainly the way in which the duty comes to an end has been subject to quite a lot of change.
And given that part of this case talks about the period between starting and finishing, what happens in what my lord described as the unexposed middle may be quite relevant.
Yeah. Well, there we are. Let's return to your submissions, Mr. Westgate.
Thank you. Yesterday I was about to go to the evidence of Mr Beasley, and what I want to extract from that is firstly the Part 7 and Part 6 policies that he refers to, and then to deal with the points he makes about the housing conditions and pressures in Croydon, and then to make various observations about what he doesn't deal with. There's a lot of material. It's a fairly long statement, and for the most part what I want to do is deal with this not by inviting you to read any of the primary documents at length, but to make the points and give you the references. I'll need to look at some of the documents.
Yes, of course, no.
But in the interest of time...
No, you do, whatever works, Mr Westgate.
So if I can start with the policies point, there are, Mr Beasley referred to a Part 6 policy, which is the allocation scheme, and also to a Part 7 policy. I don't need to take you to the Part 6 policy, but you should know that it's in the supplemental bundle, starting at page 60, going through to, it's a fairly lengthy document, going through to page 154. It's described as the housing allocation scheme, and it deals with the allocations of the authorities' Part 6 stock and other nomination rights that it has. And Mr Beasley explains that it's a scheme which sets out priorities according to banding, and the appellant was in band 3 in that, of course, of her third ground, but I don't need to deal with. Paragraph 192, which is page 95, deals with circumstances in which the director can exercise a discretion to put people into a higher banding.
So, sorry, which page did you say?
It's page 95.
Yes, thank you.
So you've got the band 1 begins at 93. And it goes through dealing with various headings about impact of accommodation. So, for example, 180, you've got severe overcrowding, life-threatening illness, sudden disability. And then 185, you've got severe health or disability-related need. And then at 95...
So sorry, I was just trying to see exactly how this... You say band 1 starts at 193, yes,
No, sorry, 93.
93. No, it's my fault.
Yes,
I meant...
Page 93.
No, I meant 93, but that says additional preference band 1, but that is the start of band 1, is it?
Yes, it is.
Yes, I see, okay. and then various headings.
Yes, I don't need to take you to the detail of
Yeah,
it.
which was the one you wanted to take us
The
to?
bits in bold. The point I noted was 192,
Yes, thank you.
which is other housing application can be awarded additional priority in exceptional circumstances approved by director of housing. It's a choice-based scheme, and the explanation for that is set out in Mr Beasley's statement. It enables people to bid. It's explained in the scheme itself at page 112, paragraph 297. But some cases don't fall within that bidding process, and among other things, that is where there is a need for an adapted property, that's paragraph 356, or to meet a legal obligation or specific statutory responsibilities.
So which paragraph for adapted properties?
356.
356, thank you, yeah.
And meeting a legal obligation is paragraph 307, and it's expressed slightly differently at paragraph 335 as meeting specific statutory responsibilities.
Yes, well, I suppose a legal obligation needn't be a statutory responsibility.
No, indeed, but it's just there's two paragraphs that cover much.
Yes, thank you. Yep.
Right. And Mr Beasley deals with this in his statement at page 38 of the supplemental bundle, paragraph 78, where he says that if a direct offer is made, then it's dealt with in band order, and then generally in dates within the band. And so the effect is that unless you're already in band 1, it's most unlikely you're going to get an allocation through a direct offer, because they'd only get to you if the property wasn't suitable for anyone in band 1. And so the result is perhaps predictable, that although Mr Beasley says that the appellant was considered for all properties as they arose, the outcome was in effect a foregone conclusion, because she didn't qualify for any property. And that is reflected in the judgment at paragraph 22.8, referencing Mr Beasley at paragraph 81 to 3, page 39 of the core bundle. And there Mr Beasley explains.
But people are in a higher band, aren't they? Because they're assessed without having higher needs than her. And then within the band, they do it by date. So the bands are sensitive to need.
Under the Part 6 allocation scheme, yes.
That's what you're talking about.
Yes, it is, yes.
Yeah. So the bands are determined by need, and then within the bands, it's by date order.
No, indeed, yes. Yes, yes, that's right, yes. And Mr Beasley explains that despite her time on the waiting list, there were still at that time 15 people ahead of her. And of course, the bands aren't static. People can come into band 1 at any time, according to the way in which their needs are assessed.
Yeah.
And so it's not you can't say, oh well, she's 15 now. In due course, she'll get to the top of the list, because there will always
Because somebody with even greater need may come in.
Exactly. And so and what we don't know from Mr Beasley's statement is whether those other people who are ahead of her are themselves Part 7 homelessness cases, whether they've been accepted as homeless, or whether they have been found to be in unsuitable accommodation. Some further information is given about that in Ms Bergen's statement. For the current position, she says how many are homelessness cases, but she doesn't say how many are in unsuitable accommodation.
That's how many of the homelessness cases.
That's right. Well, yes, well, it would only be a relevant question.
Exactly. I just wanted to make sure I had understood that.
But under the Part 6 policy, that issue doesn't make any difference. You have to wait your turn according to the way in which you've been assessed in the bounds. So that's Part 6 policy. I don't want to say any more about that. Mr Beasley also refers to a policy in relation to Part 7 accommodation. I do need you to look at that. That's at page 155 of the supplemental bundle.
Before we look at the terms of this document, which runs to a dozen or so pages, have you any submission to make about the prevalence of written policies in this area of housing authorities, in particular in relation to homelessness?
Well, all housing authorities have to have a Part 6 allocation scheme.
I'm talking about Part 7 now.
Under Part 7, I don't, in the sense I'm not able to point to the court to particular policies that particular authorities have. Obviously, we've seen that Birmingham...
No, but I'm really just concerned with the absence in the previous case of any Part 7 written policy, which I personally found surprising. We're about to look at a Part 7 written policy. I was just offering you the opportunity to say whether housing authorities have written policies as a general rule or not.
I'm not in a position to say which authorities, or how prevalent they are. I mean, it's fair to say that in one of the cases in the bundle, in Solomezzo, Baroness Hale suggested that authorities should have policies, but she was there dealing much more with the question about location of accommodation, rather than, and wasn't addressing the idea of having priorities within a Part 7 policy. And for reasons we'll come to, our position is that you can't have a Part 7 policy that disables you from fulfilling the
No, I understand that. I'm talking about the existence of policy.
No, indeed. But, as I say, and Solomezzo encouraged authorities to have in relation to location.
One of the cases we've been given.
Yes, it is. It was. It was a case about someone who was accommodated outside London, in Milton Keynes, and the question was whether that was suitable.
Sorry. Now we have been. I appreciate this. This is an inquiry not directly directed to your case, but I think could we just pin it down? It's tab 50. It's in bundle 3 of the authorities bundle. Just using you, I'm afraid, as a research tool, Mr. Westgate, rather than asking about your own submissions. You don't happen to remember where your encyclopedic knowledge of this area of the law, where she said that?
It's page 808.
Well done. Very impressive.
Well done to my
Bouquets. Yes, it's para 39. Is this right?
I'm sorry, my lord. I've somehow it looks like my authorities have a different division for when they.
Well,
yes.
yes. We'll just look at some.
But yes, so
this was a Part 7 case.
Yes, it was.
Yes. We'll just look for ourselves.
Yes, so it's 39 and 40.
It really is actually helpful to start at 38, isn't it? Well, no, I think that mustn't speak for my lord, but I think it's very pertinent to his inquiry.
Thank you very much. In an area which is so tightly regulated, it's a further surprise that apparently it isn't an obligation to have a policy, as it is in so many other areas. It seems to be a good practice.
Yes, well, it may be that the duty itself, it's because an individual duty is owed, that if you end up having policies that postpone the fulfilment of that duty, then
Well, yes. We mustn't argue the other case through you.
Yes.
But in very general terms, I suppose the point you're just drawing our attention to is that if it is an absolute duty, there's nothing to have a policy about. I think that's actually simple, but but in the real world, because we know it's very difficult to comply straight away, and that we now know there are degrees of suitability, one would think a policy would be, and indeed Birmingham thought a policy would be useful, but never actually went ahead and made it. Anyway, not fair to deal with all this through you. So let's get back to your case.
In fact, when we look at the Croydon Part 7 policy, it doesn't illuminate a great deal.
Well, it's a start to have one. Anyway, let's look at it. That's what you want us to do.
Yes, I do.
Where is it?
It's page 155 of the supplemental one. And it sets out the legal and policy context at 1.1 to 1.5. I don't need to ask you to go to that. It's really just a recital of the provisions. But then at 1.6, we see that it says that the purpose of the policy is to explain how the council allocates property when discharging its powers and duties contained within Part 7. Then it says the objectives are to ensure that when discharging statutory duties and exercising the powers, the council allocates temporary accommodation in a way that's fair to homeless households, fulfills its statutory duties and obligations, and has regard to its duty to safeguard and promote the welfare of children.
Can I just check how the word temporary is being used? Because it was used in your letters, it's also used here. Temporary in this context seems to be a description of things that is not permanent or indefinite under Part 6. It's the bit between the duty arising and when you get your Part 6 or your private sector tenancy.
Well, it's Part 7 accommodation.
Yeah.
And so it's while the Part 7 duty exists.
Yeah, it's not the Section 188 interim duty.
Well, it
may
includes that as well.
It'll include it, but it's not a shorthand solely for Section 188. It's not a shorthand for different stages within the 1932. It's everything short of the allocation of a secure tenancy or a private assured tenancy, is it, effectively?
I wouldn't want to say everything other than that, because the Part 7 duty can come to an end in other ways, but
broadly.
I prefer to express it positively, that it's everything within Part 7 rather than other...
Right, okay, but then we must not confuse it with short term for a couple of nights or short term for a couple of months and the discharge event of, for example...
No, indeed. And one of the characteristics of this area of the law that was observed, I think, in Elkundi and other places, is that although we've all become accustomed to using the term temporary, it's accommodation that can go on for a significant period of time.
Yes.
And so that's the purpose. Then you've got 2.1 deals with supply of Part 7 accommodation. And it says a range of different accommodations needed in terms of length of lease, size and location. Further information about the council's arrangements to secure supply of accommodation will be made available in the council's Part 7 accommodation supply policy. And one sees the footnote says supply policy not yet available, policy to be updated when the supply policy drafted and approved. And we don't have the supply policy either in the bundle or referred to by Mr Beasley. And we don't have anything.
And there is no evidence as to whether it has subsequently been produced and approved.
No. And as well, there's no evidence substantively about the council's arrangements to secure the supply of accommodations, discharged duties, other than the points I'll come to with Mr Beeson. And so,
sorry,
yes.
just to be absolutely clear, because there's so much technical language here. Council's arrangements to secure supply of accommodation means, whether subject to statutory powers and so on, which you're going to address it, whether to buy it, rent it, build it, or enter into arrangements with third party, effectively with housing associations. That's what supply means.
It's the full range of things that can be done to secure.
Yeah, I know, but I want to know
So-
what
so-
I want
so
to make sure that I understood what those are. Have
yes,
I got that
it's-
range
it's,
summary?
By whether a fully ready to occupy house or other land or other adaptable or buildable property. If it's not already a house to build or adapt, on your own land, to go into the private rented sector and rent something there.
I don't mean to be rude. I think you're just repeating what I said to you.
But also to give someone the means to go into the private rented sector, to rent somewhere to. But it's.
Well, would that be supply of accommodation?
It's if.
This is about allocating
It's
accommodation which the council has or has the use of.
No, if one
Give
looks
someone money, isn't.
if one looks at what section 2.1 says, it's about the council's arrangements to secure supply of accommodation.
Yeah, well, that's yes.
So it doesn't necessarily mean accommodation provided by the authority, because of course it could be through the housing system.
Well, I said that as well.
Yes, but it's the.
So I'm just educating myself. I think I don't want to spend time on things that don't really matter. But anything more you need to say about that?
No, there isn't. But,
No,
but
right.
it's certainly not at this stage. It's
Okay.
And then point 3 deals with the allocation of interim emergency accommodation under section 188. And that perhaps addresses my Lord Justice
Yeah,
Lewis's
it's part of it, yeah.
and the then, and that's described at being generally procured 3.2 on a nightly let basis. And then you have what in effect is move on accommodation. That's not a term used in the policy, which is longer term accommodation, temporary accommodation.
So this is 4. Your shorthand for 4 is move on. So
That's right.
Yes, okay.
So you've got, and so what it says is there's generally a 2-stage process. So there's the nightly let emergency accommodation, that's the section 3 of the policy.
I don't know that I agree with your reading of this. 188 is a separate thing. It's interim duty. It comes to an end once they tell you that they are now satisfied. It's not just that your apparent priority need, they're satisfied of everything. So it's not moving on. From the time that a decision is taken, 193 duties are owed, and looking at this, it seems there's a 2-stage process. They're not going to get to the discharge, ultimately the duty, immediately. There'll be stages in between.
My Lord, that is quite right. I stand corrected on the way in which the section 3 is described. But if one looks at 4.2, it contemplates that you may, while you're in the nightly let accommodation, have your 193 decision, and then you carry on where you are.
Yeah, but that's because it is suitable to do that for the purposes of section 1932.
No, exactly. Well, until something else is found.
yes, I mean I'm not criticising this. This may not be the issue, but would it accord to your understanding if 4.2 said the section 193 duty may be accepted while the applicant is residing in nightly let accommodation, so long as that is suitable?
Yes, it would.
It won't be the section 193. If you, well, if it's unsuitable and you accept it, then you're in breach,
Yes.
subject to the issue in the other case.
No, exactly, but it's certainly you could only remain in the nightly let accommodation, to use the terms of the policy, if that was suitable in all the circumstances. And of course it depends on when the decision is made. Sometimes it's a very, very simple decision that can be made in more or less immediately if someone presents. Other times it will have been a much longer period while the decision is being made, in which case the authority will have had an opportunity to make other arrangements. But we're not, of course, concerned here with the suitability of bed and breakfast accommodation in this case, because that's a long time in the past. But what this does deal with, what it does deal with, is moving on from nightly let accommodation to what's described as longer term temporary accommodation, supplied through a variety of providers under differing arrangements. That's 4.1.2. And 4.3 provides that where there's more than one household requiring a move from nightly let to second stage, then that will normally be offered with the earliest in time order. But there's a discretion in the director to do something else. And various examples are given, including impact on health and safety. And the respondent's case is, and we don't dispute it, that discretion was exercised in this case when the appellant moved to Sumner Road.
Yeah. They decided to depart from their Part 7 policy and give her priority with the initial move.
That's right.
Yeah.
And one can see that one of the other examples given where that discretion will be exercised is 4.3.5, which is some temporary accommodation specialist, for example, that has physical disability. So it, although it is described as departing from the policy, it could be a fulfillment of the circumstances.
You don't get what you would normally get if the policy were applied. You get something different because they're deciding to give you something ahead of somebody else who would normally have got it.
Yes, but in accordance with the criteria that they've already described.
But the point is, they can. It's not like the waiting list, date order only. If that's what we find the Birmingham case was. The Part 6 policy is banded. The Part 7 policy has got a structure, but you can have a result where the structure's got built within it a flexibility.
It has, but then when one looks at what their Part 4 policies, what Section 4 then says, it only deals with that situation, which is the move from the nightly let to the longer term temporary.
Yeah.
What it doesn't deal with is moves from there. So in other words, you move to somewhere which is longer term temporary, which in alley terms is suitable for a particular period of time. The authority then decides it's not suitable, and the Part 7 policy just doesn't address that at all.
Yeah.
Mr Beasley says, in his evidence, and the reference is paragraph 59, page 33 of the court Bible, that the defendants can continue to consider whether Part 7 accommodation can be used to the applicant, but one doesn't get that anywhere in the policy.
Which paragraph of the statement, sorry?
It's paragraph 33, paragraph 59, page 33. There are just two other points I want to refer to in this policy. The first is under 5.1, which is location. And I only need to take you to the second line of that, referring to the extent of demand, meaning that it will often be necessary to procure accommodation at a distance from the borough. So in other words, it refers to out-of-borough accommodation. And also, if I can ask you to turn to paragraph 8.2 on affordability. This is in a section dealing with what's suitable, and by statutory instrument, a number of factors have been taken into account in deciding whether or not something's affordable, something suitable, and they include affordability.
Sorry, which page are we now on?
This is page 161.
Which para?
It's paragraph 8.2. And it says that placement in accommodation by the council doesn't imply the rent will be covered in full by welfare benefits, or that the council will pay any shortfall, but it does say the council does have the discretion to apply reasonable charges for a household at a level less than full rent for those who wouldn't otherwise be able to pay the rent. And that's a decision to be taken at the Director of Housing Needs discretion. And of course there's also power to provide discretionary housing payments or to subsidise the rent if someone can't afford it.
Yes, sorry, and this is all by way of a gloss to 7.1.2. So 7 is how we will determine suitability. 7.1.1, sorry, paragraph is rather odd. 1.1 under 7 says particular things they'll have regard to.
Yes.
And then 7.1.2 is that the accommodation is affordable.
Yes,
and then the footnote says C section 8.
Yes. And they're obliged to consider affordability because of the suitability of accommodation, which is referred to in 8.1.
Yes.
So, Lord, that's all I want to say about the policies. Unless there's anything you'd like to pick up on them. Can I then come on to deal with some of the key points about the evidence from Mr Beasley? As I say, I'm going to take this by simply dealing with the point and then giving you the reference rather than inviting you to go to the documents. So what, and this is something which is dealt with in some detail as well in the judgment of paragraph 22, 1 to 9. And the points I'm highlighting are in particular those that the respondent is relying on in its skeleton. So Mr Beasley said that 3-bedroom wheelchair-adapted property was very scarce in the borough. He said that it was something like 10% of Croydon's own stock, 5% of housing association stock. That's page 23.
Right, so 3-bedroom wheelchair accommodation.
Yes.
Is 10% of the council stock?
What he says is that if we go to page 23, no, I'm sorry. It's some form of adaptations.
Sorry, where are you referring to?
It's paragraph 14. Page 23.
A very small proportion.
And then he says perhaps 10% it has some form of adaptation.
And that's of all stock. There's not of the 3-bedroom stock.
No. And then he says less than 5% of housing association.
Well, he says the proportion of adapted properties that would meet this case needs significantly smaller than 10%.
Yes, very small indeed.
Very small.
And he, secondly, he described the pool of available properties, and this is paragraph 86 at page 40, as being Croydon's own stock, which is just over 13,000 properties, and nomination agreements with local authorities.
Sorry, where are you reading it from?
I'm referring to page 40, paragraph 86.
What was the particular point you were taking from that?
Is that when he describes the pool of available properties, he is referring to council-owned properties and those where there is a right to nominate to.
Yeah, of course. Yeah.
But what about paragraph 90? They also search for properties in the private rented sector.
No, well that's right. But when he is talking about the what he doesn't do is say that there's a pool of properties like that.
No, but he's got a heading, the pool of available properties. There's council, there's housing association, and they actively search for properties in the private rented sector. You can't suggest that he's not having regard to the possibility of housing in the private sector, are you?
No, I'm not. What we don't have, though, is any evidence at all about how that private rented sector procurement operates. He says the temporary accommodation search for it. Later on, he says that it's too expensive. And so what you don't have in that group of properties is anything like the sort of pool that he's talking about in the sense of the number.
But there couldn't be a pool, could there? It would simply be a question of, at any particular time, what was out there.
In one sense, the pool then is every property available to rent in.
Okay, but then it becomes rather a meaningless concept.
Yes, exactly. But it's so it's. I take my lord's point that it's under the same heading.
I think you're reading too much. This is a person writing a statement. He's got the heading, the pool of available properties. What he's saying is, where can we get properties for? We've got the council stock, we've got a very high number of nominations for local authorities, we'll go into the private sector as well. If you're trying to suggest that this is evidence that they failed to have regard to the availability of private sector rented accommodation and therefore the judge is wrong, it doesn't look as if it's going to go that far.
No, I'm not saying they failed to have regard to it, but the question is the authority doing everything it can?
Yeah.
And what you have is a general statement that we're looking at the private rented sector, but nothing on top of that.
Yeah, well, we'll see what the judge makes of the evidence in due course, yes.
And he explains in paragraph 86 that stock is moved between part 6 and part 7.
Yeah.
And he says that that's against its target allocation policy. Again, we don't know how many of the 13,000 plus properties are allocated to Part 7 at the moment. He doesn't tell us. And he explains that the team were looking for private rented sector accommodation. That's my lord has drawn attention to paragraph 90. It's also dealt with at paragraph 53, where he says looking for private rented sector accommodation. He considered in his statement purchasing properties, and he said that that wasn't an option. I think he used the term silver bullet, because he said that properties started at £325,000, 3-bedroom properties, and he thought that adaptable properties were likely to be more. It is, we suggest, a fair inference from the fact that he dealt with the evidence in that way, that purchase wasn't something that had been considered. He's speculating about what might be the case,
Well,
but he doesn't deal with this.
Well, again,
words, consider it in the sense that there's no point spending time going down to the estate agents, because my experience is we're not going to get something there.
Well, his experience isn't we're not going to get something. His experience is we're not prepared to spend that much, which is a rather different point.
Okay.
Well, his point at 91, 92 is firstly what the likely cost of an individual property would be, and secondly, probably more cogently, paragraph 92, that we can't simply do this for one person without doing it for everybody similarly situated.
Well, for reasons I'll come to, we would suggest that that's not a cogent objection. What the court needs to focus on at the point of relief is what the authority is doing to fulfil its duty to
you
this.
keep saying we're coming to the. Can we just? I can't really understand the structure of your submissions. You're just referring to and summarising various little bits of the evidence. But is this the point where you're telling us what's wrong with them?
No,
Is it useful exercise to separate them out? Because you asked us to look at them, then We have to check whether they really say what they say, and then we're supposed to keep all that in our mind and come back to it in an hour's time when you say why it's a breach of duty.
Well, can I move on to the points that I say that despite the what Mr. Beasley says about the
Yes, that would be
there are
helpful.
various things that he doesn't deal with. And the first is that there was no evidence of any proactive search to find accommodation suited to the claimant's needs. And what I mean by that is that Mr. Beasley said, and it's paragraph 125, although this is in a passage dealing with reasonable adjustments, that the authority is solely dependent on a suitable property becoming available. And to paragraph 9, he refers to accommodation.
Well, hang on. So okay. So let's just see 125. Well, what's wrong with that?
But what it describes is when he talks about a property becoming available, he doesn't give any, he doesn't expand on that point. But what he seems to mean is that you wait for a property to become vacant in the council's stock, and then you apply the Part 6 policy if it's a Part 6 property, or a Part 7 policy if it's a Part 7 policy, although we've seen that the Part 7 policy doesn't cover this sort of case, rather than starting from a assessment of what the applicant requires, what the appellant requires, and then going out actively to seek to find a property that
Well, they
matches.
either will be available or they won't. I mean, how do you go out and seek a property?
Well,
And there's no point, because if there's people living in them, you're stuck.
Well, not necessarily. Not necessarily. If one, there are over 13,000 properties. We don't know how many of them are adapted. We don't know what efforts have been made to try and evaluate whether any can be adapted. We don't know whether, for example, the existing tenants could be incentivised to move, and so that property could be adapted.
Okay, let me just write this down, sorry. So, not looking for adapted properties where existing tenants could be moved out.
And
And then not looking for unadapted properties that could be adapted,
yes.
right?
And we don't, for example, know how many properties in the council's housing stock, however that's described, whether it's their own properties or housing association properties, have been allocated for use in Part 7. We know that they can be allocated for use in Part 7. We know that between the 5th of June 2015 and 26th of March 2020, when the claim started, 166 three-bedroom wheelchair adapted properties had been offered. One gets that from the Mr. Beasley's statement, paragraph 81.
I think you'd really have to read the whole of the statement with you to get a fair flavour of what they have and haven't done.
Well, it's clear what they have done, which is that they've, as properties become available, they've, in the words of Mr. Beasley, considered them. They say that they have looked in the private rented sector, but that's about it. There really isn't any other evidence of any active steps that are being taken. And as I say, we don't know, because Mr. Beasley doesn't tell us, how many of the 13,000 properties that they own they have allocated to fulfilling their statutory duty under Part 7. And
So what you're saying is that in principle they could have gone into the Part 6 stock for, well, most obviously already adapted three-bedroom properties, less obviously three-bedroom properties that could be adapted, and said that looks like it might be appropriate for Ms Imam. Take it out of Part 6 stock and therefore out of the list available for people who are on the Part 6 waiting list. Band 1 people in practice, as they're the only ones who ever get them, and allocate them to Ms Imam. That's what you're saying. I just need to know the real world what you mean.
Well, no, in the real world, what it means is that you allocate to the Part 7, to meet Part 7 need, which is the duty.
Yeah, but you're talking in very general terms. I'm talking about, you're saying Ms Imam's been here so long, they should have taken special efforts. And the special effort in this particular case is to look at Part 6 stock, which is 3-bedroom and adapted, or possibly 3-bedroom and adaptable, take it out of the Part 6 stock and use it for a Part 7 purpose, namely for Ms Imam, thereby meaning that whoever would otherwise have got it, band 1 person in Part 6, won't get it. That is what you mean, isn't it?
It's with respect, I suggest that that's the wrong way to describe the problem facing the court, because it's not about the measures that the authority should take in the sense of it's in that sense. It's a question of what the court should do to enforce Ms Imam's duty.
No, but what the court should do depends on what the council should have done and whether it's made all reasonable steps. You haven't addressed us about the law, but take that as a shorthand. And therefore, we have got to look at what the steps are that you say should have been taken, but haven't been.
If that's
that
the
must
only
be
way,
right, isn't it?
If that's the yes, but if that's the only way in which the duty can be met, then yes, but it's not the only way.
The others
that's
are
one example.
Going to the private rented sector and subsidise rent, or buy.
Well, there's we don't know about subsidising rent,
But
because
sorry, I was very rude because you are answering my lord's question. We've got to do this in a disciplined way. There are various things you say that should have been done. At the moment, you're on something in particular,
yes,
which is the Part 6 stock.
Yes.
There's no answer to that to say, well, there are other things they could have done. I'm looking at what that means. So I put to you what that means. I want to repeat it again. But basically is taking it, creating a situation where someone who would have got that under Band 1 in Part 6 won't get it, but Ms Imam will.
Yes.
And you say that's not the right way to look at it, but I don't quite know why it's not the right way to look at it.
It's because it's a submission I'll develop that the
why not develop it now?
The discussion on this topic isn't one about reviewing the authority's allocation powers. It's about what the court should do to enforce the duty. But to come to my lord's point, that does it have the effect that if we're right, then what the authority ought to do in this particular example is allocate something from Part 6 to Part 7. As it happens, that would be Ms Imam who would get it. Does that mean that somebody waiting on the Part 6 list wouldn't necessarily get it?
Wouldn't get
get that property, but of course they're on the list for any other.
Yeah, but there's a finite number, so whatever it is.
Well,
subject to your other points, but can't we take the points one by one?
No, indeed. But the answer would be yes. But the legal answer to that is the one that was given by Mr Justice Collins in Bacon, which is that the position of Part 6 and Part 7 applicants is different. Part 7 applicants are owed a duty, Part 6 applicants aren't.
So you're saying that you can't even get to Part 6, all the people to whom a Section 193 duty is owed must be provided with a suitable offer, even if it means you use up all your Part 6 stock, because it's not just Mrs Imam who would get it here, it's anyone. You're saying anyone who's in 1932 must get priority over any allocation under Part 6, because otherwise they'd be failing to fulfil their duty in circumstances when they could, by not exercising their discretion to allocate Part 6 powers. That's what you're saying, I think, is it?
Yes.
Yeah, it's a perfectly coherent position, but you mustn't be shy of it. That's quite dramatic. But you're saying, basically, Part 7, if push comes to shove, and you say, well, there are various ways in which it needn't, but if push comes to shove, Part 7 trumps Part 6, because people in Part 7 are homeless by the statutory definition, and people in Part 6, whatever, even if Man 1, aren't homeless.
Yes.
Because if they were, they would be on...
Yes, and the short answer is the powers that
Okay, well, I understand the position, but I just wanted to get it out of you.
No, indeed, but it's revealing in a number of ways, and it's a position that simply hasn't been recognised by the authority, because
By the case law or by the local authorities?
I'm sorry, by this local authority, by the respondent, because although it's accepted that some Part 6 stock can be used, the implications simply aren't followed through. What they've got to do is fulfil the duty. And that, I've got into a fairly lengthy discussion about just one of the ways we say that the...
Yes, I don't want to take you out of your course, but I haven't quite understood what your course is. I mean, sooner or later, you're going to be saying, I think, these are the steps that haven't been taken, or at any rate haven't been shown to have been taken, which should have been taken, and therefore this is a case for mandatory relief. But are we on that part of your submissions now? You're slightly saying, well, I'll be coming to that later, but...
no, I'm not going to... I hope I won't end up repeating myself when I come to deal with the further steps that could be taken. I'd hoped that it would be useful to go through the
Well, we have read
first.
Mr Beasley's evidence.
Yes.
Speaking, I hope I'm speaking from my lords. What would be most helpful is to look at Mr Beasley's evidence at the point at which you're making your criticisms
No,
of
indeed,
it,
in which case-
rather to go through it now and come back to it in an hour after. I'm not finding it terribly helpful.
But I will... I'll
From my purposes, what I really need to know is why the Deputy High Court Judge went wrong. Because I'm not quite clear now, after hearing you, what the criticism was. I had thought the criticism was they didn't realise they could use Part 6. And then I read the judgment and I thought, well, is he saying that?
No,
He might be saying that, on balance, it's not reasonable to make them use up all their Part 6 three-room wheelchair things for Part 7 people and leave nobody, perhaps who've been on the waiting list, albeit they're not homeless, for many years. But you're not saying that now. What you're saying, I think, is something quite different. You're saying it is absolute that whilst there is one Section 193 person around, they must get Part 7 accommodation. In fact, even if it's adapted accommodation, it's the only house left, and they don't need adapted accommodation, they will have to get it. It'll be super suitable, but they'll have to get it because that's the only thing that you can do to give that person the housing. They might have to get a 6-bedroomed house, and they're a single person who's pregnant. But you say, no, that is the way it works because Section 193 is absolute.
No, with respect, it's not, because we're not just focusing on that as the way to fulfil the duty. In the authorities got available to it many other options, including purchase.
Yeah, but they've got a budget deficit of £67 million or whatever.
Well, they had a projected budget deficit of £67 million, and one thing that Mr Beasley conspicuously doesn't say is that it wouldn't be open to the authority to meet a capital.
I'm wondering whether we shouldn't regroup, Mr Westgate. I've looked at how you said you were going to deal with this, and you had, I think, 7 headings. One was evidence, and I think what's happening is you've been going through the evidence, and what I hope helpfully, but anyway, my lords don't appear to be disagreeing, suggested is actually going through the evidence but not making any submissions about it, say I'll do that later, isn't the most helpful way.
No, I take the point.
Shall we then move on? Your next heading is legal framework.
Yes,
and then
I simply want to make 4 points about
right, and then principles about mandatory orders. Then 4, where the judge went wrong.
Yes.
Now I think that is the point which will answer. That's the stage where you will answer my lord's question.
Yes.
And also, because the two are completely interconnected, where the judge went wrong is his assessment of the effect of Mr Beasley's evidence.
Yes.
And we'll make all your points under that heading. Will that work for you?
Yes, it will. I hope I can come back and pick these points up. But it's
yes.
And I
I think otherwise, you know what judges are like. if you show us points, we ask questions about them, and then we lose our structure. So, legal points next, then.
Yes, you've seen the legal framework. I'm not going to take you through that, but there are just 4 points I want to make about the nature of the duty. The first is that it's one which obviously and necessarily has resource implications that must have been understood by Parliament. It's a duty which is owed to those in priority need, defined in section 189. That includes those with children, those who are vulnerable, including as a result of mental illness, handicap or physical disability. When the duty is owed, it's to provide suitable accommodation, and as my Lord Justice Lewis pointed out I think yesterday, it's got to be available for the applicant and for those living with them. So it's obvious from that that this can include families with very significant housing need. The appellant's an example, but other examples on the cases may have needs for extensive adaptations to accommodate very large families. There may be people with unique needs that can only be met by a property of a particular kind. And it's equally obvious that meeting accommodation needs of applicants like that may be costly and may place additional pressures on the authority, and those pressures have to be planned for. But equally, we say, those kind of pressures can't be a reason to deny relief where a breach is established, because if it did, then the protection of the Act would be denied to those who have need of it. Parliament is aware of the implications and has left the duty unqualified and has chosen to do so. And if the authority finds that it is in difficulty or unable to comply, then it has to seek to change the law. That's the point that Lord Justice Ward made in Our Ways, tab 38, paragraph 52, Authorities Bundle 531. I'd ask you to turn it up. That's the first point. Second point is the Section 193 duty is a duty. And again, it's an obvious point, but the implications are too readily overlooked. It's a present duty to secure suitable accommodation, which is one of result and can only be fulfilled by actually doing what the duty requires, securing suitable accommodation. If unsuitable accommodation is provided, then the duty remains unfulfilled, and that, of course, is admitted in this case. But that admission is meaningless if the defendant then seeks to defeat the remedy by relying on its role as a local authority marshalling resources to meet the needs of other people. And that is what we say the defendant does time and time again, and in substance their submissions on that were accepted by the judge, in particular when he talked about the claims of the multitude. And that fails to recognise that the court is engaged in the exercise of enforcing an individually owed Section 193 duty, and instead ends up treating the fulfilment of that duty as an exercise in judgment for the authority, and an allocative discretion that can only be challenged on Wednesbury grounds or close to it. And that reduces the duty to a duty of best endeavours at best, and in all likelihood reduces it to a discretion. And there's the related point, which I've already made, that Part 6 and Part 7 are distinct and mustn't be run together or confused. Mr Beasley suggests that it's unfair to prejudice people on the Part 6 waiting list, but the fact is that the duty under Part 7 places those who are the subject of that duty in a fundamentally different position from other applicants on the housing waiting list.
I very much see the force of that, and the point that would appeal to any legal purist. But hasn't the case law slightly sold the pass on that? Perhaps because the courts appear, though they may not have spelt it out, to realise that the Act is unworkable if it is interpreted in that way. The cases have, for a long time, while certainly saying there will be cases where a mandatory order is appropriate, effectively built the discretion into the question whether to grant relief. And you can see that going right back, and it is accepted by Lady Hale in her, though it wasn't the issue in Ali, she looked more widely, and she acknowledges there are plenty of cases where the council just can't fulfil its duty, and then there won't be relief. Now, I see why to a lawyer that seems wrong. Now, what's the point of having a duty if you can't enforce it? But haven't we got there in the case law now? We can't go back on it.
Well, no, we haven't, because the case law doesn't suggest that appeals to general resources or allocated concerns like that can trump the duty. They do leave a discretion open to the court as to when it grants relief, but it's pitched at the level of impossibility or close to it.
But impossibility is all very well to say. Nothing is impossible if you have the resources, but the real world people don't have resources. They have competing claims on limited resources. And the concept of impossibility in the case law doesn't seem to mean only, a earthquake destroyed a whole housing estate. The sort of impossibility they're talking about is impossibility caused by a mismatch between demand and resources.
Well, except that apart from this case, there aren't any cases where relief has been refused on that basis.
Okay.
They
You'll be coming to this later when you come
Yes,
to that.
yes,
Okay.
so
Then I'll stop asking you about it. But thank you.
that's the third point, and
Yep.
it builds really on. And we do say that subject to rationality, the authority can use all of its stock for Part 7 purposes, because those on the Part 6 list don't have any entitlement, and the authority doesn't even have to have any stock itself. And we don't shrink from the proposition that if that's the only way they can meet their Part 7 duties, then that's what they have to do.
And if they've still got people left who are 193, then they'll start going out and buying property.
Yes,
Releasing it.
or buying or any of the other options. But it may, of course, come to the point where if the authority is legally unable to act, then
And when there's a conflict of duties, when they've got people who have care needs, children, and when they have people who have duties owed to them because of their disabilities otherwise, under what used to be the National Assistance Act and so on, when there's a clash of duties, when you've got 47 homeless people in front of you, 33 children who are entitled to services under Section 17 of the Children's Act, and other adult people who've got all sorts of other things, and they've all got duties, we simply say to them, well, that's all right, cut the highways, cut the litter collection, the money you've got has got to be used for duties first, and let's hope you fill all the duties. But if you've still got some left over, which ones and how does the court decide not to enforce that?
well, the court's function is to deal with the case in front of it, primarily. And we, with respect, the point that the Lord poses is hypothetical in this sense, in that the claim hasn't been made that the authority can't afford to do what's being asked.
No, but
It's-
okay, but the point is, are we not in, I mean, what is, you come on to it, but what is the purpose of mandatory relief? Is to try and get the duty fulfilled. If they don't fulfill it, what you are supposed to do is seek contempt proceedings, and indeed there's authority saying you can put councillors in prison if they don't comply with it. But that's the Armageddon purist solution, some might say. The question is, what is the test, and have they acted reasonably trying to balance all these things? You say, no, you just look at the case in front of you, she's got a duty, that's it, they must have properties, there's something out there at Croydon, that's all we've got to deal with. But is that realistic if you're asking this court to grant a mandatory injunction, the result of which is the Croydon councillors can go to prison if they don't do it?
Well, on the evidence, we say it is realistic. And perhaps what this discussion highlights is that even if you aren't with me on what you described as the purist approach, it pitches the level of what the authority has to do at a very high level indeed, that they have to satisfy the court that they really are in what Lady Justice Arden referred to as an impossible position, and as Mr Justice Collins and Bacon said, that the court shouldn't be readily satisfied that that's the case. And so the court does need to be extremely exacting about asking what else could be done, and not simply assume that because a point is made in fairly general terms that, well, this will prejudice another group of people, that that's good enough.
Taking that as a reasonable statement of the proper approach, there seem to be two ways in which this problem could have been solved for your client. One would have been taking property away from somebody who the local authority thought had priority, which gives rise to obvious issues of fairness. And the other would have been spending resources which they say they don't have. So, is it not possible to apply an extremely exacting test and reach the conclusion that neither of those things are possible in the real world?
Well, I will. I don't want to avoid answering my Lord's question, but I was rightly moved on from getting into what the options are.
Be that as it may, you've said if you're not with me on the absolutist position, which is we have a duty we get, regardless of the consequences, except for what you described as legally unable to act, which I presume is a euphemism for the council going bankrupt, not being entitled to spend any money. What's wrong with the second position, which is the exacting requirement, at which point one has to confront both fairness to other people who have an equal claim or a better claim, or expenditure of resources which are not obviously available?
Well, the fairness to others problem does inevitably drag the court into treating what ought to be an exercise in enforcement of the duty into asking whether the authority is acting rationally in the way in which it's allocating.
There are 16 people who have a better Part 7 claim than your client. Either the local authority has to accommodate them all, and quite possibly all the other people behind them under Part 7, but certainly the people in front.
Well, we don't know that the people ahead of the appellant in the allocation queue are people who are owed Part 7 duty. They may not be owed a duty at all, either because they aren't Part 7 cases or because they're presently unsuitable.
Well, at the moment, I'm not meaning to go to the exercise of the discretion, but just to what the test is. Granted, it's extremely exacting. Why are matters such as resources and fairness not relevant matters in imposing an extremely exacting test?
Well, you have my answer, which I feel you may feel is too purist or absolutist, which is the one just given.
But if the absolutist answer is not the answer, and we must consider it, of course, but if it's not the answer, then surely they are relevant matters in imposing a very exacting test.
Well, if one is going to take that into account at all, then one does have to have precise information about what the scale of the other...
I understand your fallback position to be that if the absolute position doesn't work, at least the test is exacting. And what that means is the council has to prove it to the hilt. And really, the exercise we stopped you doing, but you will eventually get the chance to do, is to say, look, if they're going to say they haven't got the resources, they haven't given us any details about budgeting generally in the council. If they're going to say it's unfairness to others, they haven't shown who these others are. They've given us a few very high-level figures, but we haven't got the kind of detail that would enable the court to be satisfied. That's structurally how your fallback argument works. Is
Yes,
that
it
right?
is.
Yes. Let's.
And
I will stick to my previous and say let's get through the principles. I think it's quite useful as we go through them to test them a little, which we've just been done. But as to testing them for the facts of this case, we'll do that when you've got
yes,
to the end of them.
and while it's still in my mind, if I can just make one point about the exacting approach, I anticipate that one of the points that may be made against it is, well, that's just unrealistic. It forces the authority to produce all sorts of data and material that is onerous for them. To which we say absolutely not so. If you're going to take the duty seriously, you should have done that legwork anyway. You should have worked out exactly what the impediments were in you meeting your duty in this case, and you should easily be able to explain it to the court.
Are you also, in deciding whether or not to grant mandatory relief so that the house will be provided within a particular period of time, are you entitled to have regard to the extent or the reasons why it's not suitable and the length of time for which that has continued? Or is it just absolute, once you're homeless and you're in priority need and the duty arises, that's it? It doesn't matter what or how serious the deficiency in the accommodation or for how long?
Well, it's again the
It's the principal question, first of all.
yes
So it's yes or no.
well you can't in principle.
Cannot take account of the degree of failure, or the degree of unsuitability.
Yes, it may, where it may come into play would be, and I appreciate you may feel this is just reclassifying the problem, but it would be the way in which the court responds, in the sense of the amount of time it gives in order to provide accommodation in those circumstances.
What about length?
Well,
The time that somebody's been there. Is the court blind to that? And if somebody says, look, I've been here 15 months and there's no sign of anything happening, and the other person says, I got my letter yesterday, I'm homeless now, I'm do it.
well,
They look at length. I'm putting it in extreme terms to try and get a clear answer. Is it yes or no? You can look at length in deciding when to enforce it.
the court can, of course, decide that in its discretion not to intervene at a too early a stage. That's been clear since.
So it's permissible then to have regard to the length of time that the person has been in an unsuitable accommodation.
Yes,
That's
but
one of the factors in deciding whether or not to grant relief.
But within limits, because when one looks at because what the authority, what you can't then do is have a time which is so extended that it ends up being destructive of the duty. And that's what's happening in this case, and it's happening in perhaps other cases.
That's why the length of time might be relevant.
It might be, but when one looks at the way in which the authorities have addressed this, Mr Justice Collins in Bacon referred to a few days after the decision had been made, and Baroness Hale in Alley talked about a short while. And so, although of course it's right to test the proposition by reference to extremes, the reality is that what the authorities appear to contemplate before the court will grant an order is something which is a much shorter compass than what we're talking about here. And it may well be that the longer time goes on, the firmer the steps are that the authority would be expected to take to find accommodation. But can I press on, because I can see that I'm going to need to make some submissions, or sort of truncate some of the submissions I'm making. I was going through some, I was making the points about the...
You were on 4 points on the legal framework, and we had the first two.
The third one was the parts 6 and 7 being distinct. The fourth one is this is an anticipatory duty, or there is an anticipatory duty in the sense that the authorities have a duty to plan to ensure that suitable accommodation is or will become available, and there's an obvious good sense in that, because it means that the authority doesn't have to hold a particular stock but they can plan for a number of ways in which they meet the accommodation needs. And you've seen in Zolomezzo, it's also something which is dealt with in the Homelessness Act 2002, which I don't think you've looked at yet. It's page 177 of the Authorities Bundle. And it's section 3. By section 1, I don't need to take you to, authorities have to formulate a homelessness strategy. And section 3 says what it needs to include. And it's a strategy formulated by them for preventing homelessness in their district and securing that sufficient accommodation is and will be available to people in their district.
Yes, where's the duty to have a homeless strategy?
It's section 1.
I thought that was defining what it was. Sorry, you said section 3.1 defines a homelessness strategy. Where does it say it must have a homelessness?
No,
section 1. I'm sorry.
That doesn't actually. It says may from time to time.
Yes, but then section 3, subsection 3, shall exercise that power to ensure that the first homelessness strategy is published within 12 months.
Yeah. Where's that?
It's 1, 3, and 4.
Oh, 1, 3, right.
And indeed,
okay.
4.
So they can do it whenever they like, but they must do it within those periods.
Thank you.
Yeah.
Thank you. Right.
What I was then going to come on to was the
Law
principles on which
on mandatory orders, yes.
mandatory order names.
I think we need to look at those.
And there are really 4 points here. The first is a matter of principle, that the court should grant effective relief in the absence of cogent reasons not to do so. The second is that in this context...
Hang on, sorry.
I'm sorry.
Court should grant effective relief,
Yes.
absent cogent reasons not to. Okay, yeah.
Second is that in this context, that is translated to, at least in the case of a prolonged breach of this kind, to an obligation to grant relief unless the authority shows that it's impossible to comply, or in some formulations that there's nothing else it can reasonably do. And
Hang on. Yep.
And thirdly, it's not necessary for a claimant for relief to show some special impact on them in order to obtain relief. And specifically, it's not the case that the court can deny relief in the absence of evidence to show that the position is intolerable, or that the stage has been reached that enough is enough. The proposed tests from Ali.
So sorry, not necessary. So that, as you're saying, the proposed tests in Ali don't apply?
Exactly.
Yes, I see.
And fourthly, the authorities' resources, or rather lack of them, are not a relevant consideration at stage of relief.
Now, those are very crisp, and I know you're keen to get on, but I mean, are you about to show us the authorities that make them good?
Yes, sir.
Yeah, right, okay.
So the point 1 about the what can perhaps be described as presumption of an effective remedy follows from the long-established principle that where there's a right, there must be a remedy. There is, of course, a discretion in granting relief in judicial review, but it's right to say that there are no cases that have been produced to this court where that kind of discretion has been used to permit a substantial and continuing breach of duty. and in particular, there are no cases where relief has been refused because of concerns about budgetary pressures on the authority.
Well, that's your
Apart
point
from
4.
this
Yeah.
We accept that the court can decline to make a coercive order where the public body can be relied upon to comply.
Because you say a remedy, I mean, very often a declaration.
No, exactly, and it's fair to say that the court perhaps prefers to interfere coercively as little as it needs to. And so if it's satisfied that the educative function of a declaration will produce the result, then it doesn't need to go further and make a mandatory order. In fact, that's what Mr Justice Collins did in Birmingham.
Yeah.
And it may well be that many of the cases we've got are examples of that. Hendy might be an example in the judgment of Lord Justice Steyn. But what lies behind that is the body's got to be, the authority court's got to be satisfied that the public body is going to comply.
Yeah.
And it may well be that this is the explanation for my Lord's point on short periods of time not leading to the court interfering, because where the period of time hasn't been very long, the court might well feel, well, we're satisfied that the authority is going to get on with it, or at least we don't have any material to suggest they won't. But once time continues to run, and the months turn into years and many years, then the court simply can't have that level of confidence. And so it would be appropriate to intervene at that point. It's a point which is, and I'm not going to take you to it because of the time, but I do ask you to look at it, which is, it's recently been dealt with by the Supreme Court in Craig and H.M. Advocate, which is tab 64 at page.
It's literally last week, isn't it? Or the week?
Yes, it was. But one of the issues arose in it was what the effect of a declaration was, and the parties appeared to think, well, it was just a declaration; we didn't have to act on it. And what the court explains is that fundamental to the rule of law is the trust between the courts and the executive. That when the courts say what the law is, or where the law is established, the executive will.
I'm beginning to wonder if this is actually about the discretion of the court. If the purpose of granting relief is to try and get authorities to do what they're supposed to be doing, very often they don't understand what their duty is, so you declare it and then they go off and do it, and you approach it in that way. But here I think it's a different problem. They know they're in breach of duty. They've said throughout they're in breach of duty. They said they'd very much like to provide the housing, but they can't. And I think this really is more a question of law as to must you comply with Part 7 over and above Part 6 and other duties. Because what they're saying to us is, well, we're taking other things into account. And yes, we've got this duty, but there are other competing things as well. And I think you're really saying you've got to comply with this duty.
Well, yes, we are. And when the matter comes before the court to adjudicate on, the court needs to focus on what the authority is doing in relation to this case and whether it can comply in this case. And the consequence of the respondent's argument, and the argument, well, there are lots of other powers, or rather lots of other duties that we're not fulfilling, is to produce what we suggest is the truly absurd position, and one which can properly be described as offensive to the rule of law, that the authority said, well, the more cases that we're in breach, the less the court should intervene, because we are the ones who need to be able to decide which of the many people we're in breach to. We will satisfy that duty.
But the court is granting relief because it wants to make it sure that the duty is recognised and that the authority is doing what it needs to fulfil it. I mean, if we grant a mandatory order, they've got to do various other things. You want a mandatory order because it'll be contempt ultimately, and on existing authorities you can go against individual councillors if they don't do it. So you're asking us to start the process of coercive relief leading to imprisonment to get the house. That's the question. If that's the context, the question then is it appropriate for the court to do that in circumstances where they accept the duty? And that's why I wonder whether the real question is you've got to say to them, you've got to do it. you've got to prioritise Part 7 over Part 6 at the very least. And unless you can say you've done that, you've had it.
Well, so if the position was that the authority was saying we have to keep some Part 6 stock back, and that's what's stopping us fulfilling the duty, then there would be considerable force in what my lord says, and it would be really rather like Mr Justice Collins and Begum, where the authority didn't think about using its Part 6 stock and had a policy not to. And once that block was out of the way, then you could see a way through to the duty being fulfilled. I don't understand the authority to be making that point, although they certainly haven't demonstrated the converse of that. What they haven't demonstrated is that even if we gave all our Part 6 stock into Part 7, then it wouldn't help. If one got to that point, then of course it may well be, if that's a way of securing the duty, then that would clearly fall within the discretion of the court, because it would be the declaration serving its educative function, which would then allow the authority to act on it.
Well, I think we should keep going with your.
Well, my lord, yes.
You are on your first of your 4 points. You should grant effective relief.
Yes, well, yes. So the first one,
and you've referred to Craig, which is really in the background. Keep going.
Yes, the other case we refer to, and again, I'm not going to take it any further than our skeleton, it is the Client Earth case, which is our skeleton at paragraph 40, and there the court asks what is the only realistic way to secure compliance. And so the guiding principle, perhaps if there is one, is what realistically is necessary to secure compliance with the law. And the court mustn't ever lose sight of the fact that that's its objective, to secure that the duties are fulfilled and not turned into something else. And where the court denies relief, absent the usual cases like delay and conduct of the claimant, but then it tends to be in cases where the breach is one which is trivial, or perhaps would have made no difference, or where the claimant has got everything they need. And examples of that, and I'm not going to take them to you because of time, are two of the cases that the respondent relies on, Degnan and Walters, which are pages 350 and 353 of the authorities bundles respectively. What we say is the principal approach has been applied in a number of housing cases, and you've seen most of them in the course of the last 2 days. So, and again, given the time, I hope I can be forgiven for not taking you to them in detail. The first one, and the one that we say is still authoritative and sets the tone, as it were, for the remaining cases, is Mr Justice Collins in Begum.
Well, you have to be careful about that. It's a first instance decision. This is about the eminence of Mr Justice Collins. We're not bound by it.
No, I appreciate that.
Well, anyway, we saw what he said. Yeah.
I shouldn't have said authoritative, but it's an approach which has generally commanded the approval of other cases, of judges in other cases. You've seen what he says. I'm not going to take you back to it, but it's although the court won't enforce unreasonably, it will do unless it's satisfied that the court counsel is doing all that it could, and he refers to the court not being persuaded by, lightly persuaded by alleged impossibility. That's page 382, 384 and 386. On that case, he granted relief. In that case it was a declaration, on the basis that the authority had excluded its own stock on the basis of a policy that it held. That's at page 385, and we emphasise that because it becomes relevant on the virus point. And secondly, there was no evidence that they considered stock outside their area, and that's also something we say is pertinent here. The next case in our skeleton is Nazir Khan, I won't take you to anything on that that's not in the skeleton, but I do expressly invite you to look at paragraph 16 of that decision, which we deal with at paragraph 51 of our skeleton, where, having set out a number of factors, he addressed an argument about whether or not resources should be one of the factors the court should take into account, and he expressly gave the answer, no, it shouldn't.
You say, don't you, that Khan is wrong because he didn't need to go through 5 factors. It's the law of the duty.
Well, he didn't need to, in the sense that he could have dealt with it in the same way as Mr Justice Collins did, by starting with the, but there's nothing inconsistent in his case, in that case, in doing so. And on the facts of that case, it was a case where the duty was only acknowledged right at the end, when the case started, and those are factors that may as easily be said to go to the relief the court will grant, the time that the court will give, as well as whether or not it's going to grant the order itself. And so, but we also don't say that those factors are irrelevant, but that they are ones which have to be seen in the light of the test in Begum, which is then followed through in the later cases. There is then a series of cases from Cardona and following on from it, and the judgment of Justice Lord Justice Old. The only point I'd make in relation to those is that you were shown the passage in Cardona and also Sheridan and Slattery that followed that, and in particular there's paragraph 32 in Slattery that my Lord Justice Lewis referred to. There are really 2 points to make about that. One is that each of Cardona, Sheridan and Slattery were statutory appeal cases. They weren't judicial review cases, and so the question of relief simply couldn't arise in those cases in this sense, because under the section 204(3) of the Housing Act, the County Court has power to quash, affirm or vary the decision. It doesn't have power to make a mandatory order. And so those couldn't have been addressing in any authoritative way the test for relief. So far as the substance of those cases is concerned, we see the force of the point that's made in relation to Lord Justice Old, that he may have been had his eye, as it were, on relief rather than the nature of the duty. And if that's right, then he does, on one view, appear to pitch that at the level of reasonableness rather than impossibility. But the explanation of that, we suggest, is in the passage at paragraph 32 of Slattery, where the argument being addressed there was whether the authority couldn't show that it had done all that it reasonably could because it hadn't made provision for caravan sites. And so and in the passage that is referred to in paragraph 32, when the court talks about reasonable time, they're talking about the reasonable time that the court gives, rather than reasonable time before the court intervenes at all. The closest we suggest that the cases come to an authoritative statement are the judgment of Lady Justice Arden in Arways, where she made the point that she didn't rule out a case where the court may refuse relief. She says it's paragraph 65, page 533 of the authorities bundle. She says, I wouldn't, at least without further argument, rule out the possibility that the court may decline to make a mandatory order in a case where the authority is placed in what is in effect an impossible situation. And the reason I say that is the closest that we come to there being a directly applicable statement at this level is that in Arways at first instance, Mr Justice Collins granted mandatory orders. When the matter went to the Court of Appeal, 3 of the appellants still had not been housed. The appeal was dismissed, and although it didn't mention the mandatory orders, the effect was that the earlier judgment stood on those points. And it was in that context that Lady Justice Arden said what she did.
You're entitled to say what she said was pretty tentative.
No, indeed. I'm a long way from saying that that's a test that you are bound to apply. But that's the context of it. I'm grateful to the Mr Nabi, who was on the appellant's teams in the early cases, for that summary of what the position was with the orders, because it doesn't appear directly from the judgments.
But they were granted declarations by Collins J, not mandatory orders.
They were granted mandatory orders. He adjourned the question of relief. He made it clear he was going to grant a declaration. But he then, you see, I think from the last paragraph of the judgment, that he adjourned relief.
And at 516, when you get the little note in the official law report, that appears to say, by a decision, this is page 5 and 6, let it be, by a decision dated the 26th of January, Collins J allowed the claims of granting declarations in each case. That's why I thought he granted declarations, but you're telling me it was the mandatory order, the prerogative mandamus.
Yes, it's...
So the note's wrong, is it?
It doesn't reflect the copy of the order I've been shown, which is that said it did indeed grant a declaration, but said the defendant, you have a period of 4 weeks from today to discharge its duty under section 193. But perhaps we can provide a copy of the order to you.
That's almost a mandatory order.
Well, yes.
Well, in fact, it is really a mandatory order.
Yes.
Shouldn't be done that way. The declaration should be that they were in breach, but a declaration that you should do something within 4 weeks is an order that you do.
No, I'm sorry. There's a paragraph I didn't read, which was the declaration, and that was the mandatory bit of.
Where were you reading from?
It's a copy of the.
Could we have a copy over lunch?
We don't have a copy, but we'll produce one.
Yes.
So that was the position always. Then M and Newham and Elkundi are both cases where the court applied an approach of impossible or unreasonably difficult to find suitable accommodation, but of course in both those cases they were satisfied that wasn't made out. And it's a fairly lightning run through those cases, but what we suggest is that...
And perhaps, just to fill this in, it is important since it is the highest authority. Lady Hale refers to this rather allusively in her judgment in Ali at para 51. She says, nonetheless, there will be cases where the court ought to step in and require an authority to offer alternative accommodation. That's mandatory.
Yes.
Or at least to declare that they are in breach of their duty so long as they fail to do so. Now, that hints at, alludes to the possibility that you may make a declaration without a mandatory order. Have I got that right?
Yes, it does, but one can see that that's... well, there are 2 points about that, and I'll
were you were coming to that?
I was going to come on to that in some detail.
Oh, I'm so sorry. Well, let's come to it later.
This is the first clear point where the judge goes wrong.
Okay, well then, if you're coming to it later,
yes.
Don't say any more about it.
But what we say that it emerges from these cases, because our point is that Lady Hale and Lord Newberger in Ali were not addressing relief at all.
No, I understand that, but don't.
So
Well, either deal with it now or deal with it later.
No, so on the cases that do deal with it,
yeah,
we say that the themes that come out of the authorities, because we accept there's no binding authority that sets out a clear test, are that firstly refusing relief in the face of a clear duty, and where no compliance is forthcoming or likely to be forthcoming, is, we suggest, a residual or exceptional course, and we rely on our ways for that, We also rely on the judgment of Lord Justice Sedley in the Tyneside case. It was an education case, but he made a comment to much the same effect, which we refer to on our skeleton of paragraph 49, Authorities Bundle 672. Second point is that the stress on these authorities is consistently on what the authority is doing or can do to comply. And that makes sense because the duty is on them, and if they're not complying with it, the primary question for the court is why not? And what can be done to secure compliance, rather than the court getting into a debate about how bad the non-compliance is. Third point is that the burden lies on the authority, and that follows from the way that each of these cases describe the approach. It's framed in terms that it's for the authority to show why an order should not be made because of the difficulties it has, whether it is impossible for it. And that again makes sense because only they know what the difficulties are that they face. And whether that's described as a general proposition or whether it's described as simply a matter of evidentially shifting the burden when you've got prolonged delay, perhaps doesn't matter. But the point is it's for the authority to explain why they can't comply. And
the purpose of an order is to make it clear the duty is owed and to get it complied with. And you're saying it's got to be coercive. There's no separate test. There's a duty and that's it. You grant a mandatory order. You tell them you must do it within 6 weeks because you want to be able to come back and bring contempt proceedings.
no, my lord, I'm not saying that. Certainly, in a case where the court is satisfied that by resolving whatever it is the issue is between the parties, that will produce the result, then of course the court won't immediately reach for a coercive order, because the court in those circumstances, in compliance with the Craig approach, will be able to rely on the mutual relationship of trust between the courts and the executive.
But in all these cases, we know they're in breach. They've accepted they're in breach, and they've been in breach for months, and they haven't done it. So the only purpose of getting further relief is not to establish that they're in breach. Everyone knows that. It's to say to them, you must do something, because if you don't, and what is the if you don't? You want a mandatory order. The only purpose of it, surely, because we know of the breach, is to put them in prison.
Well, no. The object of the order is to secure compliance with the duty.
Yes, and how is that going to be done?
Well,
Because they go to prison if they don't comply with it.
Well, there is a halfway house, isn't there? That they might not respond to a declaration, but that they will respond to a mandatory order, not because of fear of prison, though that's always there in the background, but simply because the court has told them to do it.
No, exactly.
Which is different from saying this is what the law is, but
and we aren't at that stage yet anyway. We're at the stage where the authority is saying, yes, we're in breach. It's terribly unfortunate, but we can't help you because we've got all these other things we have to do. And so we're not even at the stage of the court having declared everything. Indeed, the judge below thought, well, there's no point in a declaration because they already know they're in breach. But the fact is that their knowledge that they're in breach simply hasn't brought to bear the level of effort needed to secure compliance with this duty. And we're at the stage, in this case, where, given that admission, which the authority and the judge appears to have thought were matters in their favour, and to a certain extent they are, but given that admission, we're at a stage where it is difficult to see what practical effect a declaration would have. And so the only thing left is for the court to be more directive. And the only tool that the court has to do that is by way of a mandatory order.
okay. Well, we got your submission on that. What's next?
So I was going through the points that one gets out of the authorities, and we said that while I think I'm on point 4 or 5.
The last one I got was burdens on the authority to.
Yes, and the next point, which will be 5, is that while impossibility hasn't been universally held to be the test, the standard does require the authority to do everything that they can. And
Sorry, what was 4?
4, I think 4 was the burden on the authority, but
No, it was.
if that was 3, then 4 is impossibility, not.
Yeah. Okay.
And although sometimes that's referred to what the court, what the authority can reasonably do, we make 2 points on that. One is, what's reasonable here is a question for decision by the court and not the authority, if that is the approach. And secondly, the stress is as much as on all that is reasonable, as opposed to simply reasonable. So it's not good enough just to show that the authority is acting reasonably. And it ties in the point I made earlier, that if you don't like the absolutist approach, that the court has to be very exacting indeed, and be satisfied that the authorities doing everything.
Okay.
That's the second point. The third point on general principles, because
So I got really confused.
No, I started by saying I was going to go through 4 points on the approach to mandatory relief.
Yes, I see.
The first was general point of principle. The second was how it's played out in the housing cases. The third is impact on the claimant, and the fourth is resources.
Okay, all right.
I'm moving on to the third one now, impact on the claimant, and we accept that in a number of cases evidence has been given about impact on the claimant, but it's never been held to be necessary for information, for evidence of that kind to be given. We don't say that such evidence is irrelevant, because particularly it may affect the urgency with which the court acts. But except in a case where the impact's trivial or de minimis, it can't, we suggest, lead to a refusal of relief altogether, and to send the claimant away empty-handed, at least not where there's a significant ongoing breach with no limit or prospect of one.
We're talking here about mandatory orders, not declarations.
Well, I don't want to. In this case, our position is quite clear that nothing short of a mandatory order will do the job.
It's a peculiarity, it's a feature of this case that you didn't even get a declaration
No, indeed.
in relation to the homelessness.
On the basis that the judge thought, well, we didn't need one because the authority was still.
Yes, so you say, as it were, obviously you should have had a declaration in circumstances of this sort. But you're really pitching at the moment in relation to mandatory orders.
Yes, but we say that the admitted breach ought to have led to a declaration.
But it doesn't really matter. The point, what the appeal is about mandatory relief.
No, exactly.
Okay, well, and where do we go now?
No. So there are 3 reasons why we say that impact on the claimant shouldn't have a bearing on it. The first is that if you demand it, then it distorts the duty. Because the duty is met when you are homeless, eligible for assistance, in priority need, and not intentionally homeless.
I just wonder whether the language you're using presupposes the answer. The question is, you've got to consider granting mandatory orders. If you haven't got evidence from the claimant about the day-to-day practical effects of what it's like to live if you're disabled without access to the toilet or the overcrowding, you may be able to look at other material. You've got the report from the OT person, you've got Beasley and so on, but it's not demanding it, it's looking at the evidence to see what you've got. And you're not punishing the claimant, you're simply saying, well, she was in the position, she was the best person to know, and she hasn't been prepared to say, with a statement of truth, this is just unbearable. You just don't know the humiliation that I'm going through.
If I understand your point's a point of principle, it doesn't really matter whether it's unbearable or not.
No, exactly. What we're saying is that the test is whether the section 193 criteria are made out, not whether 193 is made out and it's unbearable.
Well, look, but I thought you said the evidence wasn't irrelevant.
But it's,
and then you switch it and you say, but it's not necessary. But if it's relevant and it's not there for whatever reason, then isn't it something that the judge can take into account?
Well, no, when I said it wasn't relevant, I said it wasn't irrelevant. I was saying that the relevance of it is that it affects the urgency with which court acts.
To be fair, I wrote that, but relevant only to urgency.
Yes.
Is that, have I got that right?
And perhaps to the form of order that's made. But anyway, you had the first point of principle, which is that if in substance you only grant relief when you can show it's unbearable, then you are adding something to section 193 and reordering the priorities set by Parliament.
Yes, down my next.
The second and related point is that it ends up putting applicants in competition with one another, and frankly, a competition they can't ever win, because they will not know what the position of other applicants is, so they put in evidence about how unbearable it is for them, and then they're instantly defeated with the authority or coming and saying, well, what about all these other cases? And the court simply can't evaluate those things, because however much information it's given, it's going to find it very difficult to say, well, this case is worse than that one. And so it robs the court of its power to intervene.
Isn't that contradicted by M and by Elkundi?
Well, except
So it
that,
robs the court of its power. There's a case in which the court did just that.
yes, but those weren't cases where the reason for the grant was that this was the position become intolerable. Those were cases where the relief went in N because the finding was that the authority wasn't taking things seriously, frankly, and in Elkundi because the authority hadn't even argued that it was impossible or unreasonably difficult. So, anyway, you have the point.
It's a duty. We shouldn't second guess it. Once they've crossed the threshold and it's unsuitable and they're in priority need, that's it. We shouldn't then second guess and say, well, some duties are worse than others or some breaches are worse than others. That's the minimum Parliament has set. And once you reach that minimum, you've got to comply with it. And it's not for us to empty the content of that by having a 9/10 fulfilment of the law.
Yes.
Right. Well, what was your third point?
The third point was it's inconsistent with the burden lying on the authority. And the next point I make under this heading is that it's specifically not the case, as the judge appeared to think, that there is some test of intolerability or enough being enough, which is something that he took from Ali and Birmingham. We set that out in our skeleton at 60-62, but it is one where I think we do have to look at the judgments in Ali. So if I can ask you to take up bundle 2, page 536.
Yep.
And the first passage is that of Lord Hope, paragraphs 3 and 4. Paragraph 3, and I'll try and take this quickly again because of time, but it's paragraph 3. Lord Hope is, having associated himself with Baroness Hale, goes on to deal with Cadona, and says that he prefers the approach in that case to that of Miss Justice Collins, and that's clearly talking, we say, about the content of the duty. Then at paragraph 4 he deals with Lady Justice Arden in our ways, and that's a continuation of that discussion. And he says, just against letter G, having that he agrees with Baroness Hale, the court must have regard to the practicalities of the situation. Then he refers to Cadona. The court will not make an order to force the local authority to do the improper possible. On the other hand, it may well feel it's proper for it to step in at the time it's allowed to elapse intolerable. And then he says, the point which I wish to stress is the description of the duty in Cadona is with respect the one that should be adopted in preference to that of Lady Justice Arden. Now, in relation to the point he's stressing, that clearly goes to the nature of the duty. He is favouring the reasonable time approach as opposed to the immediate approach. When he talks, we suggest, about the time that the court may step in, which when the time that's been allowed to elapse becomes intolerable, that's what he's addressing. He's addressing that the reasonable time is too long. And what he's certainly not doing is suggesting that there's any kind of additional test of intolerability beyond that before the court will grant an order.
Okay.
And in fact,
Got the
that's,
point there.
and really the same point applies to the judgment of Baroness Hale and Lord Newburger.
I think it's only the judgment of Lady Hale.
It's a joint judgment, yes. And before I get to that, I want to show you paragraph 27, page 547, where Baroness Hale explains that the issues before the House are whether accommodation, which it's not reasonable to expect the applicant to occupy, and to deal with that, and then the third point is remedies, which is duty. But of course, by the time the matters came to the House of Lords, everyone had been accommodated, so there's no question of any remedy at that point. And at paragraph 64, at page 556, she says at the bottom of that paragraph, as all these families have now been allocated suitable accommodation, no other remedy is called for. We'd not be inclined to enter into a debate about the criteria governing the granting of relief injunction in homelessness cases. So having identified it as an issue at the time, they expressly decline to get involved in it. That is, we say, an unpromising starting point to suggest that at paragraph 47, that's in fact what she was doing. And again, when you read those passages, it's clear that they deal with 47 to 51. It's clear that 47 through to 49 are dealing with the length of time that you can leave somebody in accommodation without being in breach of duty. And paragraph 50 deals with that question too, right to face up to the practical implications of this conclusion. And she then goes on to deal with the question where someone has been left for too long a period, which is exactly the thing she's asking about earlier on. And so when she talks about the paragraph 51, to the court stepping in and requiring an authority to offer alternative accommodation, or at least to declare breach of duty, she's again addressing the question of breach of duty rather than the question whether relief should be granted. She's addressing the question when enough is enough in terms of the accommodation that you're occupying and the length of time that you've occupied it.
I mean, you may be right. I see the structure. It doesn't quite work, though, because she has talked about those occupying unsuitable accommodation. The natural reading is the situation of a particular applicant in her present unsuitable accommodation may be so bad.
Well, it may be.
It may just be. I would really say this, but I will. She was just speaking rather loosely.
Well, it's without going over the debate that raged on this over the first 2 days of this appeal in the Elkundi case. It is clear that their suitability and reasonableness aren't always used in their precise designation, and it's difficult again to see how, if it is referring to remedy, it's intended to operate, because if the threshold for unlawfulness is whether something has become intolerable, in the words of Lord Hope, or whether it's reached the stage of enough is enough, then how can you have the same test apply to whether or not there should even be a declaration? Because Baroness Hale is referring to mandatory order or declaration. So what content can be given to the additional bit of intolerability or enoughness that's necessary before you get relief? So that's impact on the claimant. I'll deal very briefly with lack of resources, which is my fourth point on this. As an issue of principle, that shouldn't come into play when one is dealing with remedies for a breach of an unqualified duty. The reason for that is that it ends up qualifying the duty and turning it, in effect, into a discretion or some other kind of best endeavours duty. And secondly, it interferes with the court's practical ability to enforce duties because it involves the court being dragged into resource allocation decisions which are traditionally treated as being non-justiciable. And what that suggests is that our primary point is that that means that resource considerations ought not to be considered at all. But if they are to be considered, then it would only be at the level where the authority can demonstrate something pitched at the high level of impossibility, rather than requiring the court to get engaged in a kind of Wednesbury judgment, because otherwise that makes it unreasonably difficult for the beneficiaries of the duties to enforce their rights. We derive support from the general proposition from the decision of the House of Lords in Tandy, which is tab 23 at page 306. That's Authorities Bundle 1.
But didn't that say that the duty itself included resources as part of deciding what the duty owned?
Yes, it was. It wasn't a relief case.
That's different.
Well,
And you've got cases like Barry that go the other way when you're dealing with other duties. Some duties are absolute, some of them are resource qualified, to use jargon.
No, indeed. But if I can just show you the passage, because it's something which we say is equally applicable to relief, even though we accept it's about the duty.
Not about relief, yeah.
And so it's
Page 306 in the bundle.
page 306 in the bundle is where the authority starts, and the bit that we need to look at is page 341, Lord Brown Wilkinson, letter B. And it says, if I can ask you to read the bit against letter B very understandably. And then at D, where it refers to Barry and the suggested control being Wednesbury, and then says, but with respect, this is a very doubtful form of protection. Once the reasonableness of the action of the local authority depends on its decision how to apply scarce financial resources, local authority's decision becomes extremely difficult to review. The court can't second guess the local authority in the way it spends its limited resources. And then it goes on to say at E, Parliament's chosen to impose a statutory duty. In my judgment, the court should be slow to downgrade such duties into what are in effect mere discretions over which the court would have very little control. If Parliament wishes to reduce public expenditure, then it's up to Parliament so to provide. Not for the courts to adjust the order of priorities. Now, I accept entirely that that was about the interpretation of the duty in the face of an argument that the authority should be able to rely on resources. But each of the points made there are equally applicable on the point of relief. If otherwise, the court's going to get itself into the position of, through the medium of relief rather than interpretation, watering down an unqualified duty. So that's the principal point about resources. So far as section 193 is concerned, that the same applies, we say, with greater force, because in section 193, all those resource questions have already been dealt with when it comes to the question of deciding whether or not accommodation is suitable or unsuitable. If a decision is made that something's unsuitable, then it means that the authority has decided that, notwithstanding all the pressures it has on resources, this accommodation won't do and something else has to be provided. And it's then...
Is that right? I know, just remind us, and so I don't want to slow you down, just remind us of the provision that says that resources can be taken into account.
It's the passage comes from Sakapima, and it's...
I don't think we've been taken to Sakapima, but we've been told about it, but not taken to it.
But you get it from Kadona. I think that so that might be the...
Well, wherever you want to take it.
So bundle 2, please. Sorry. The Roman passage is 413. Sorry, this is Sakapima. but it's so.
Sorry, I got confused. What is Sakapima?
What I've shown you, I've taken you to. I've shown you. 413 is a passage from Sakapima.
Oh yes, sorry. So it is.
No,
we were taken to it. I'm so sorry.
Yes.
And you say it was approved at the.
Exactly. It's never been doubted as a proposition. But the point is that you can look at it in deciding what's suitable. But once you've made that decision, an appeal to resources is of no avail.
Well,
and
no, but that's what worried me about it. It could be financial restraints and liberties, housing stocks, and master could be taken into account in determining suitability, but there will be cases where a property is unsuitable, even though
that is right. Yes.
And it's really that's the case we have to look at in order to test the principle, the hard case.
Yes, it is. But again,
But you were suggesting, oh well, the resources problem has already been disposed of when making a decision it's unsuitable. Not necessarily.
No, I can see that, but it's also right to say that the resources that the authority is entitled to take into account in relation to Sakapima perhaps falls some way short of impossibility. So that they're entitled to take into account much more general pressures on them. But given the structure of the Act, we suggest if resources can be taken into account at that stage, it's then inconsistent to have them taken into account at the point of relief. And I won't develop that further given the time. So I was going to make some comments on the defendant's approach to the duty, but I will deal with that. I won't deal with that now, and we'll proceed straight to my point about where the judge went wrong.
Yes.
And the judge dealt at length with the factors he considered to be relevant, paragraph 81 of the judgment. And the overall criticism related to that is that the judge didn't give effect to the thrust of the authorities, to the effect that where there's significant...
Sorry, didn't give effect to what, sorry?
To the thrust of the authorities on principles on which mandatory relief is granted.
Sorry, I must be going deaf. To the what of the thrust?
Thrust of.
Thrust.
TH.
You mean the thrust? What do you mean by the thrust of the authorities?
The proposition to be derived from those authorities that where there is a significant ongoing breach, then the authority must show why.
Oh, sorry, it's this confusion about authorities. You mean authorities in the sense of case law, not...
I am sorry, my lord.
No, it doesn't matter at all. I'm just explaining why I didn't understand you. Now I do. Yeah. Yep.
And in effect, and none of the factors identified in his paragraph 81 refer to the authority demonstrating that it cannot comply, and in some they don't add up to that state of affairs being found or justified. Instead, the judge approaches the discretion as a general exercise without appreciating the force of the imperative to uphold the law.
It's two failures. One, it's not what he said so much as what he didn't say. The starting point shouldn't have been general discretion. The starting point should have been, I grant a mandatory injunction, and you've got to show me why not.
Yes. That, of course, being a case where, because of the approach the authority had taken, this wasn't a case where a declaration would do.
There's no complaint about that. I mean, your real complaint is he should have started off paragraph 1. The normal principle is in mandatory injunctions for a breach of this nature. Paragraph 2, they haven't done anything to show me why not.
Yes, it may well not be necessary to say that mandatory injunctions will follow, but if he'd said that the normal principle is we've got to grant an effective remedy that ensures that the duty is fulfilled, and by a process of elimination you then end up with a mandatory injunction.
Or a mandatory order.
Yes.
It's really mandatory.
I'm sorry, it's a mandatory order. I'm using the wrong.
Yeah, should grant an effective remedy to ensure compliance, which would be a mandatory order, and didn't then consider whether the authority had demonstrated there was a sufficiently cogent reason. But he didn't realise the defendant had to do that, and the defendant didn't do that, is it?
Yes. and there are really three headings that I want to develop on this point, where there were specific failures on the part of the judge's reasoning. The first is where he dealt with the claimant's circumstances. We deal with that in our skeleton argument at paragraph 62. He referred to the claimant's failure to adduce evidence that her position had become intolerable. That's at 81.1. And we say it can be seen to be a key part of his reasoning, because he returns to it at 81.4, 81.7, and at 82, where he says it's particularly significant. And as we've already suggested, evidence of a claimant's individual circumstances are of little, if any, worth in a case like this. But at all events, it was wholly wrong for the claimant to be looked to establish by evidence, and this is quoting from 81.1, to establish by evidence that her present situation is at the level discussed in Ali.
Okay.
And to require that was to misunderstand and misapply Ali, and to commit the other errors that we say apply under that head, and I won't take you back to that. Even if the judge was entitled to require evidence from the claimant, he had it, and this really comes back to the points I was making yesterday, because on any view there was evidence of the impact of the property on her and the difficulties that it caused her. It may not have been as extensive as the judge would have looked for, but there was evidence of that difficulty, and the current impact was admitted. That's a passage from Mr Beasley that I showed you yesterday.
He does refer to the letter of the 23rd of April 2015.
No, he does.
And he says he set it out. He doesn't have to set it out again, does he?
No, I'm not making a point of that kind. But the thrust of what he's saying, though, is he's just discounting the evidence of impact on the claimant, because she hasn't shown the intolerability threshold, and he hasn't recognised that the evidence was there as to what was currently the position.
There are two things. Taking the second thing first, hasn't recognised the evidence. He refers to paragraph 8, and that talks about the defendant's difficulties, incontinence, it happens in the night, causes humiliation and distress. He has had regard to it. By cross-referring, the question is, separately I think, was he right to say that the evidence that was available had to reach the level of intolerability?
Well, indeed. Now, I dealt with the intolerability point, but on the second point, it's not good enough in the context of this reasoning for him to just refer to the 23rd of April letter. Of course he can cross-refer, but what he goes on to say is there is simply no evidence about the present effects and on day-to-day life, and then he goes on to endorse the point that it may have been ameliorated. But the fact is there was evidence about the day-to-day effects, because there was the letter of the 23rd of April, the claim form was in the present tense, and Mr Beasley says that he accepts him that.
Okay.
So the difficulty is that he not only applied the wrong test from Ali, but he ended up discounting the evidence of impact altogether, because he thought there was none of it when there was. So that's the first point. Second point is in relation to the matters that the authority could have done. Because we say it wasn't open to the judge on the evidence to find that the respondent had done all that it could. And this really brings me back to what I was saying about Mr Beasley's evidence, because although he identified a significant amount of activity, there were serious gaps pointing to other steps that could have been taken. And I pointed, when I was taking you through this initially, to the lack of what I described as a proactive approach, that is, trying positively to find accommodation for the appellant which would suit her circumstances. And we set out a number of options in our skeleton at paragraph 67, and I won't repeat those. But in addition to those, the position is that there's no evidence about attempting to procure units outside the borough, even though the authority's own Part 7 policy says that properties can be sold outside the borough.
I thought you didn't want accommodation outside
Well,
the borough.
that-
I mean, it would have been unsuitable, wouldn't it, to move her and the 3 children who are presumably at school outside the borough?
Well, the latest evidence is to
We
the
haven't
effect
got it, so don't refer to it.
it's.
I mean, how, if they'd said there's a property in Newcastle, I mean, it's,
Well, it depends. But the point is, what they haven't done is made any searches outside the borough at all.
what in circumstances
It
when you
certainly
think-
wasn't part of the case below, but she
she
wouldn't
didn't
accept
want
it.
it outside the borough, does she?
It wasn't her case below that she didn't want to go outside the borough. And on the contrary, the point was made that
didn't want to go any further than Bromley or Kent, is that right?
Well, the effect of the new evidence says.
No, it's the new
No, no.
evidence. I'm so sorry.
Yes.
I chose
But
those.
the judge can't criticise for not looking at the new evidence.
No, it's my fault.
But there was no evidence before the judge that she would not accept a property outside Croydon.
But was it part of her case that they should have?
Yes. I understand it was put on the basis that it simply wasn't accepted.
No, I was just puzzled because this point isn't in the skeleton. It's rather often when points out in the skeleton, it reflects they weren't the point below. But
But it was put on the basis that it wasn't accepted. There was no property anywhere.
But I thought I think reference to saying location was good. I've seen positive statements saying that it was good. So I've come to the view, as often happens, that people don't want to move themselves from their networks. They don't want to move their children. So I need to show something that said this was a live issue and there was a factor. There's lots of things they could do. They could check Newcastle. She might be prepared to move to Newcastle. But if she says, I'm not going to Newcastle, then there's no point in them looking over Newcastle. So where's the bit that says, how can you really assume that she's prepared to go out of borough?
Well, it's not about assuming whether she will or won't go out of borough. It's about whether the authority has done everything it reasonably can, if that's the test.
But it's not reasonable to require them to look at out of borough unless there's some indication that it would be reasonable.
Well, look
it
at
would
it.
be acceptable. Take Newcastle. It wouldn't be a failure to do all that was reasonable possible because they didn't bring the housing in Newcastle because she obviously wouldn't want to go to Newcastle.
Well,
so I think you've got to show, if we're dealing with reasonableness, that there's something to suggest that it didn't matter to her whether it was Bromley or Wimbledon or Haringey.
Well, there's what we don't have is what you often have with the homelessness application is people ticking what boroughs what areas they're prepared to look at. But would you bear with me one moment about what was put below?
I've just been looking at the skeleton argument below. I can't at the moment find anything about not failure to consider out of borough.
My lord, can I deal in this way? What Steinhardt tells me is that the way it was dealt with below, or the point that was made below, was that it wasn't accepted that there was no property anywhere. I'm looking at the housing market.
Well,
generally.
anywhere is an ambiguous term.
Anywhere
It might normally
anywhere
be anywhere in Croydon.
Anywhere in the country. And the reason why that wasn't explored, or the reason why maybe the authorities' various point, which is that their point was, well, we can't go out and acquire property because it will always end up having to be disposed of in a way that we can't give it to you. So but the point is, it's not open to say that there was no.
Well, what I suggest we do on this point of how it was put below, let's see what Mr. Rutledge says about it. Maybe it's a non
Put or not put, it reveals an important point we suggest about the proactive steps that need to be taken. The duty lies on the authority. It's for them to take steps to discharge it. And it's not for the applicant to say, well, here are the things you should do, although of course I accept that forensically it's helpful to be able to point to those. But one of the things that one might have expected, for example, would be that the authority would get to the point where they say, well, look, we've been trying to find you somewhere for 5 years. We've been looking in Croydon, but we can't find anything? Can we have a discussion about where else you might be prepared to go to? And there's no reason at all why an authority shouldn't do that when their own policies say we may have to source accommodation outside the borough. And there's no evidence that they've ever looked anywhere other than within the boundaries of Croydon.
Now, I see the time.
Yes,
Now, we're going to have to let you go on a bit after lunch, but Mr Rutledge has got.
No, of course.
How long are you going? Are you
Well,
asking?
Lord, it may be that, although I had said perhaps rather optimistically when I started, that my last point was going to be relief if we win, on the basis that we would then be addressing the new evidence to the NASA. And although I'm reluctant to suggest a course of action that might end up with submissions being split, it may be that if I don't deal with that and just deal with the error points.
Well, let's suppose we don't deal with that. How long are you going to be?
I think probably about 20 minutes.
That should leave you enough time, Mr Rutledge. The person coming second doesn't have to cover so much ground. Well, I think I will be more generous than that. I think, but this will be an absolute cut-off. I think you must be sitting down at 2:30 or before. Just see, perhaps, do I need to be so generous? You've got one or two more points about where the judge went wrong.
I've got some more points about where the judge went wrong.
Well, we got the ultra vires point, which I thought would take a little time. That would be rushed.
The ultra vires point I can probably take fairly quickly.
All right. Look, we'll hold you to 20 minutes then. We maybe not be absolutely strict. If you think 20 minutes is what you need, that's what you can have.
My lord, I do apologise for getting up perhaps after 1 o'clock. Well, I've had a very helpful conversation with my learned friend outside. We just wanted to be sure that we hadn't misunderstood what your lordships had requested. Because getting every copy of Part 7 since the Act was passed and then cross-referencing it would take a little bit of time. In terms of which section 193 applied to which claimant, we're in a position that we can provide the court with an agreed note at 2 o'clock, and those sections, whichever version applies, is already in the authority's finding. Would that be sufficient, or would your lordship?
No, well, this is what I thought we wanted, and my lords can chip in at the risk of our appearing disunited if they don't agree. I thought we wanted a complete copy of Part 7 as it stood in the case of each of the appellants, right? The time to which their claim relates.
Right.
Right? That's just a mechanical business of identifying it on Westlaw and printing it. Yes. Ideally in PDF format rather than that funny format you get otherwise, but if that can't be done, that can't be done. That's probably only one set, because although they were different dates, I'm not sure they were any of them were dates at which the Act was in a different state.
Yes.
But that is the main thing we want. What we also wanted was a note explaining the changes to section 193. This is what we asked for yesterday. Up to the state in which it was at the relevant time. Have I got that right? Yes. Those are the two things we want. That obviously wasn't what you thought we wanted. That's
well, I misunderstood, and that's my error.
I don't think they're very difficult. There may be a bit of copying to be done.
The point is this: if you're trying to decide whether the claimant was treated unlawfully, you need to know the law that applied to that case.
Yes.
There's no good showing me 96 and then me suddenly realising it didn't apply. It's no good you showing me 131 when that didn't apply, and when the law that applied to the material time is different from the law that we've had 3 days arguing about. So what we really need is the copies that relate to the applicant.
So we will provide a copy of the Act as it was at the time it applied to each claimant.
Yes, but hopefully that's only one.
Hopefully that's only one. There may be two, because
Okay,
The last
fine.
case, there was an
You can
amendment.
work that out.
And then secondly, and this is one I just want to be sure that I understand, a note as to how 193 at the material time applied to each claimant.
I think that's right. What?
So that would be quite a short note again.
I thought the note was about when 1753 and
Yes,
2006 was
that's right. I'm sorry, I misled you about that. That's but my lord reminds me. It was the point that came up yesterday about two related points. One, when the law changed so as to be introduced 1753,
Yes.
and two, when the law introduced the requirement of suitability.
Yes.
You told us verbally,
Yes.
orally, that that was on the same. That was in the same act, though different sections of that act.
Yes.
Some of those sections, I think you said, were already in the bundle. Others you've handed up today. All we wanted, and I'm sorry if I misspoke earlier, all we wanted was a note just stating that, so that and exhibiting exhibiting these.
So,
Sorry if I got that wrong.
no, my lord. I'm very grateful for your.
No, it's although the situation is not of our making, I'm sorry if I've made it more confused. Right. Well, we will say
Sorry,
1 o'clock.
I may have overlooked exactly what I meant to be dealing with after lunch. Am I going to be dealing with remedy or not in my 20 minutes? Or
No, I think we will. We'll have a word outside. You can have till 2:20 to deal with everything except remedy. If we think we want to hear you on remedy, we will give you a little bit more.
I think I'm ready.
Does that make sense?
Yes, it does. Yeah. Okay. Oh, then how long do you reckon you're going to be? Not long, I don't think.